Hello everyone, and welcome to our session today on Schrems2 and the impact on Australian organisations, or as we're calling it, Schrems Season 2, Episode 2. Thank you very much for joining us today, and my name is Nick Abrahams. I'm a partner and also the Global Head of Technology and Innovation for Norton Rose Fulbright. And today with me on the Australian side, I will have also my colleague Jim Lennon, who is a special counsel in Sydney and also the head of our privacy practice in Australia. Today also features a cast of quite a few people from our international offices as well. And so we've got Marcus Evans, who is based in London and is the head of the European Data Protection, Privacy and Cybersecurity Group. We've got Christoph Ritzer, who is a partner in our Frankfurt office. David Kessler, who's a partner in our New York office, and also the US head of data and information risk. We have Lara White, who's a privacy partner in our London office, and also Shiv Dadar, who is an associate in our London office. And I think that's one of the benefits of the webinar experience, is that we can bring all of these extraordinary people to you today. It would have been extremely cost prohibitive to fly them all to be in one room with you. So here, via the webinar experience, you get the best seat in the house, namely your house, and to listen to our experts discuss this extraordinary topic. And I say extraordinary, as the Schrems2 decision is really the latest chapter in a long and convoluted history of litigation in the Irish and European courts, focusing on the intersection of European privacy rights and US government surveillance law. And in fact, the origin of Schrems goes all the way back to the disclosures by former NSA contractor Edward Snowden. So today we will talk to you a little bit about the tremendous effects on international transfer of personal data from the EU. And it's not just relevant for the US, but it's also relevant for other countries, including Australia. And Jim will cover off that right at the outset for you. And there is really an urgent need for businesses to understand this new privacy landscape, predominantly as it relates to Europe and the US. But as I said, it is other countries as well. And so right at the moment, we're really waiting for regulatory interpretation of what this case actually means and how companies can respond to it. Also there is a quick plug for the book that Jim and I wrote recently, Big Data, Big Responsibilities. And so that is available in all good bookstores and online. But also, as you are listening to this webinar, we'd be very pleased to provide you with an electronic copy of that book. So please do feel free to send an email to either Jim or to me and ask for a copy of that book, and we will send you a copy of that book at no cost. And it's widely regarded as the Harry Potter of privacy books. So I mean that in a facetious way. So it's definitely really only of interest to privacy people, I think, and those who are interested in privacy. And as I said about the book when we launched it, it's if privacy and cyber issues are keeping you awake at night, then read our book, because it will put you to sleep. So with that, feel free to reach out to either Jim or I to get a copy of the book. We would be delighted to make that available to you. And with that, very pleased to hand over to my colleague, Jim Lennon.
Thank you very much, Nick, and hello, everybody. It's fair to say the Schrems decision has caused quite a deal of excitement in privacy circles, and for any set of corporations which exchange data in meaningful ways. In a modern society, that's an increasing number of corporations and businesses of all types and the occasional government agency. Schrems has been a long time coming. This is Schrems2 after all. I don't want to steal the thunder of our European and US team who are coming after this, but a lot of the focus on the Schrems decision has been on the EU-US privacy shield. And that's a framework through which, a kind of a legal conduit, if you like, through which personal information could be transmitted lawfully between organisations in the EU and in the US. Now, if you're an Australian organisation listening to this, you might rightly be disinterested in that, and in fact it's not very interesting. What has caught people by surprise is that it has very important implications for the standard contractual clauses that many Australian organisations have put in place, sometimes reluctantly, in respect of information transfer transactions with organisations in the EU. The reason that Australian entities rely on the standard contractual clauses, or the SCCs, is because they provide a kind of safe harbour primarily for the data exporter. So that's the organisation that's sitting somewhere in the EU. And there are very few bases on which a data transfer is permitted to a country outside the EU. And one of those was, for example, if you were the US, you had the choice of either the SCCs or using the privacy shield. And not to sort of preempt too much of what Marcus will tell us, but that privacy shield is just gone. There's nothing to salvage, it's gone. The SCCs, interestingly enough, are a second layer. And people had thought that once you put the SCCs in place, that was more or less a done thing. It was never quite that, and Lara White is going to explain more about that. But the SCCs, once that documentation was put in place, it was something of a set and forget, and it was designed to fit in with a series of approvals, most lately in 2010, that if you had these clauses in place, the data could be lawfully transferred to a third country. And so that's the way we proceeded. And so it now appears that the SCCs are still required, but they are not necessarily sufficient. And the problem is that we don't know. Amongst the many parts of the Schrems decision was a finding that the laws of the recipient country, so this is Australia's laws, need to be assessed, and they need to be assessed in respect of how government agencies in particular can access that data. The problem with the US was that the NSA, the National Security Agency, had wide mass surveillance powers. They could, without sort of focus on a particular offence or individual, they could simply suck up huge amounts of data, and that was contrary to the privacy protections and the Charter of Rights in the EU. So it remains to be seen whether Australia has any particular law, or even combinations of laws, that might offend those principles as well. And this is a very, very complex legal question. It's complex because when in coming to do such an assessment, the criteria for assessing it aren't actually known. So we have, we can look at the judicial process in which the US laws were assessed in the Schrems case, and that's instructive. But in terms of how we deal with situations going forward in different countries, and Australia is the one we're thinking of just for the moment, but in countries all around the world, how we assess a group of particular laws against a range of privacy scenarios and work them back against a set of principles under EU law to work out whether they are compatible and acceptable is in fact a very, very complex exercise. It might well be the case that we could do an assessment for one client and a particular privacy scenario today and find that it's fine and the SCCs are sufficient and don't need any additions. But a different scenario tomorrow could require substantial changes. And our thinking is that those changes could be either technical. For example, you might need to introduce end-to-end encryption in order to prevent interception. There could be organizational in terms of what uses or disclosures can be made and how it's to be stored and managed. And they could be legal in terms of introducing forms of redress, for example, and other restrictions. So each of these is a question yet to be determined. One of the things that privacy lawyers as a group are waiting for are the responses from the EU regulators. because in the end, the SCCs are an EU instrument. Somewhat helpfully, the SCCs have been subject to review for quite a long time. And in fact, they were expected to be revised before the GDPR was put in place. And that's now a substantially late exercise. However, there's an indication that they're trying to fast track a new version of the SCCs so that that may provide not only a better set of terms that are more compatible with the GDPR, but may actually provide guidance as to what additional measures might be required. So there's a lot of things that we don't know yet. The regulators are still working through the decision themselves, and the guidance that they offer, of course, is highly relevant. It's relevant because if we on this end perform an assessment of Australia's laws, and so we the Australian organisation might be the data importer, and that's discussed and agreed and signed off with the data exporter in the EU, it is still open for an EU regulator to form a different view and effectively strike down that arrangement and require the data transfer to stop immediately. Now, that has very important implications for business. If your Australian business activity depends on receiving or processing data, and it could be an HR centralization exercise, it could be processing billings, customer information, logistics, etc. If those arrangements can be brought to a quick and sudden end with the prospect of GDPR scale penalties on the far end for non-compliance, there are substantial risks and uncertainties. And so this is the problem that the privacy profession is grappling with at the moment. So look, without further ado, I would like to hand you over to Marcus Evans from our London office, who will take you into the meat of the decision.
Hello, everybody. My name is Marcus Evans. I'm a partner and I lead the European Data Protection practice here at Norton Rose Fulbright. So today we're going to look at the background to this decision and the turmoil that it seems to be creating, what the judgment said about the standard contractual clauses, and what the judgment said about the privacy shield, and how regulators have reacted to the judgment. And then we'll sum up with what actions exporters and importers should take in response to it. So I'm going to hand over to my colleague David to take you through the background to the data transfer turmoil. David, over to you.
Thank you, Marcus. The Schrems2 opinion focuses on the quote-unquote mass surveillance that the U.S. government has been undertaken and that was revealed by Edward Snowden, primarily looking at both the upstream program, where the U.S. has tapped into the underwater cables and is reviewing information coming into the United States, as well as downstream programs like PRISM, where with the assistance of various ISPs are able to apply selectors to specific electronic communications. These programs are authorized under the Foreign Intelligence Surveillance Act that was amended in 2008. Given our brief time, I do not have the ability to go into the history of this statute or all of its nuances. I think it's important to understand that it is limited and guided by Executive Order 12333, as well as the Presidential Policy Directive number 28. Also, I think it's crucial in our understanding and looking at the scope of this opinion that the court does not address surveillance with inside the United States and all of the attendant privacy protections and controls that limit it once the data exists within the boundaries of the United States and is resident on servers therein, but focuses on the ability of the U.S. government to conduct this analysis and the surveillance as the data is outside the United States or is coming into its borders. And one has to understand that this authorization has been particularly scoped to focus on non-U.S. persons and to avoid privacy protections like the Fourth Amendment. That being said, it is also crucial for us to understand as we consider its effect on the standard contractual clauses and the additional safeguards we need to consider and whatever supplemental guidance we're going to need to provide as data importers and as data exporters, that both the authority and in practicality, the surveillance is not unlimited, that there are protections in here, but also that there are technical limitations, and that we may be able to provide practical safeguards that protect the personal information of EU data subjects that avoid the surveillance in its entirety or mask the information in a way that eliminates the surveillance for corporate communications, business-to-business communications, or specific communications that are of interest to our clients. Before we can get to those practical points, we are going to review the scope and nature of the concerns and the analysis that the court requires. With that, I will turn it to Shiv to discuss the timeline and how we got to where we are today. Thank you.
Thanks, David, and hello, everybody. So I'm going to set the EU scene by running through key events that have led to this judgment. After the Snowden revelations, one of the most famous international privacy cases, colloquially known as Schrems2, arose following a complaint against Facebook by Max Schrems, who argued that the transfer of his data from Facebook Ireland to Facebook in the US based on the safe harbor export regime was unlawful given the law and practices of the US's surveillance programs. To a lot of people's surprise, the Court of Justice of the European Union invalidated the safe harbor regime due to the lack of adequacy between the regime and the requirements of EU law. Whilst political negotiations were ongoing to find a solution to the issue, many organizations entered into the standard contractual clauses as an alternative. Eventually, a new political agreement was reached between the European Commission and the US government, which resulted in Safe Harbor 2.0, what we all know as the EU-US Privacy Shield. Privacy Shield, however, has been subject to scrutiny by both the European Commission and the EDPB. While the European Commission was rather favourable about the effectiveness of the Privacy Shield in its latest annual review, the EDPB was more critical, particularly regarding the lack of oversight of US companies that self-certify to the regime as regard to compliance with the principles of the Privacy Shield, the absence of or the limitations to the rights usually afforded to individuals under EU law, namely the right to object, the right to access, and the right to be informed for HR processing. Criticism also arose around the absence of key definitions, the applications of the principles when it came to data processors, the lack of guarantees on transfers for regulatory purposes in the field of medical context, the lack of specific rules on automated decision-making, and the overly broad exemption for publicly available information. In the meantime, Max Schrems argued that the Irish Data Protection Commissioner should suspend the transfer of his data by Facebook Ireland to Facebook US, which is now being covered by the standard contractual clauses, given the findings in Schrems2 that US law did not provide sufficient safeguards for individuals' rights in the context of US surveillance. The Irish Data Protection Commissioner, in essence, referred questions to the Court of Justice of the European Union about the validity of the standard contractual clauses more generally. The case, colloquially known as Schrems2, was heard on 9th of July 2019. Just before Christmas last year, the Attorney General issued his non-binding opinion in this Schrems2 case. The Attorney General concluded that the standard contractual clauses were valid as an export mechanism, but not always, and not in every case, and that an assessment of the national security surveillance laws of the data importer needed to be conducted to make sure that they met EU standards. The Attorney General commented on Privacy Shield in particular that he entertained certain doubts as to the conformity of the Privacy Shield decision to Article 45(1) of the GDPR, read in light of Articles 7, 8 and 47 of the Charter of Fundamental Rights and Article 8 of the European Convention of Human Rights, but he stopped short on opining on the validity of Privacy Shield. I hand over to Lara now, who will discuss the impact of the Schrems2 judgment.
Hello, everyone. So as Shiv mentioned, the key question that was put to the European Court was whether standard contractual clauses are valid. They also, among other things, were asked to consider whether data protection authorities are actually required to suspend transfers made pursuant to standard contractual clauses if they determine that the protections of personal data can't be adequately ensured. And I'm now going to discuss how the court answered these questions, so specifically what the judgment said in relation to SCCs. So as I'm sure many of us will agree, before the judgment, the use of standard contractual clauses was very much a paper-based exercise. I think companies around the world would generally enter into them with very little thought about what they actually said. And it was effectively thought that if you signed them, you had a free pass to transfer data to the relevant importer without any further steps being taken. And in considering the question of whether the SCCs remain valid, the European Court has made it clear that it's not as simple as this. And in summary, it followed some of what the Advocate General has said, or a large part of what the Advocate General has said. So it said that it was satisfied that the standard contractual clauses are a valid means to transfer personal data, but said that there were a lot of further considerations around that, and that the standard contractual clauses might not be on their own sufficient. So the main issue in question is that whilst the standard contractual clauses bind those who have actually entered into them, so the exporter and the importer, they don't bind anyone else, such as law enforcement agencies or authorities, intelligence agencies, other public authorities in the importing country. And therefore, depending on the laws of the importing country, the SCCs may on their own not be sufficient to ensure adequate protection of personal data. The court therefore said that it's necessary for the exporting entity to make a case-by-case assessment of whether the laws and practices of the data importer ensure adequate protection for personal data. And that if the laws and practices don't meet the requisite European standard, then it may be necessary to supplement the guarantees that are in the standard contractual clauses using other means. And where those other measures can't be taken, ultimately the transfer ought to be suspended. Now, on the DPA point, the Data Protection Authority point, the judgment also made clear that data protection authorities have obligations to suspend or prohibit transfer to a third country where they take the view that in light of all the circumstances of that transfer, the standard contractual clauses cannot be complied with. And I'm going to take you through each of these components in a bit more detail, but it certainly does seem that there might be something in what Bruno Gencarelli said, Bruno Gencarelli being the head of the International Data Flows and Protection Unit at the European Commission, when he said last week, Schrems2 changes data transfers from theory to practice. So I think the key point coming out of the judgment in relation to standard contractual clauses, other than the fact that they remain a valid mechanism, is this requirement to undertake an assessment. And the key question that everyone is asking is, well, how do we make this case-by-case assessment? What factors need to be considered? And paragraph 104 of the judgment says that the factors to be taken into account are the same factors that the European Commission has to take into account when it is assessing a country's application for adequacy status. Now, these factors, which is worth mentioning or worth noting, normally take a committee of experts at the Commission years to research, are set out in Article 45(2) of the GDPR. And as you can see, it's quite a long list of items. But importantly, we don't read the judgment as requiring companies to do an adequacy assessment and consider all of these points in relation to all of the data protection and other laws applicable to a data transfer. It certainly is the case, and I think this follows from the fact that this judgment is looking at what measures might need to be in addition to SCCs. It certainly is the case that some areas of European data protection law, such as data subject rights, can be appropriately and adequately addressed through the standard contractual clauses alone. So instead, what we need to look at are the areas that can't be addressed through the standard contractual clauses. And at the moment, the areas that the court has identified are in relation to surveillance, public authority, mandatory access to data. So in relation to that public authority access to personal data, what paragraph 104 of the judgment and Article 45 of the GDPR makes clear is that exporters need to assess the laws of the country and the rules around them in relation to public authorities' access to personal data. Are those rules clear? How is the rule of law viewed in the relevant jurisdiction? Are the laws proportionate with regards to the legitimate interests pursued? And this is a point that was sort of flagged in the judgment. They also have to consider whether there is an independent oversight mechanism in relation to the access in the jurisdiction concerned, and also whether data subjects and not just residents of the importing country can enforce rights and obtain proper redress in relation to the access. Now, of course, this assessment is clearly easier said than done. I mean, firstly, the exercise just might not be very simple because the laws governing intelligence agencies' practices are not intended to be very well signposted, and they can be very opaque and very specialist. In fact, talking to David and talking amongst ourselves, we think probably the US actually has one of the more transparent surveillance regimes, and it's certainly hard to see how you might make a positive assessment of many other jurisdictions' regimes with a straight face without having obtained specialist local advice first. The second issue is the cost-risk analysis. It could just be cheaper to use European service providers rather than complete this assessment only to get it wrong and then face regulatory fines or have to unwind an offshoring. And of course, fines for breaching data transfer rules are in the higher echelon of the GDPR fining regime. So that puts quite a sort of focus on this. The third point, and this is the key point, is what the scope of the assessment is. Is the assessment based just on the third country's laws and its practices and the rights and remedies available, regardless of whether you think that actually the data being transferred will be accessed by the public authorities, or should a broader, more risk-based assessment be undertaken? And that was more what was advocated by the Advocate General in his opinion before Christmas. In his opinion, the Advocate General said that the examination that he was noting is required entails a consideration of all the circumstances characterizing the transfer, which may include the limitations and safeguards ensured by that third country to protect individuals' rights, the security measures in place, the types of data and how sensitive it is, and the nature and purpose of the processing by public authorities. And I think from this last point, we can read, the likelihood of the data actually ever being accessed, requested by the public authority. So the Advocate General clearly was advocating a more nuanced assessment, and of course this isn't without its challenges. You could still have a positive assessment in light of all the facts, but a person might subsequently become a person of interest. But this flexible approach certainly seems more appropriate than a narrow examination of third countries' laws in complete isolation, especially when those third country laws might not even impact the data actually being transferred. But the court isn't explicit on this point. The judgment does refer to an assessment being made on a case-by-case basis, but it doesn't say anything about this more nuanced assessment that the Advocate General mentioned. I mean, certainly if we look at the list of points in this slide, the first 2 points are quite clearly called out. So the fact that you have to make an assessment of the limitations and safeguards around the law, and the fact that you might have to put in place additional safeguards, which we'll come on to. But the points around the type of data, how sensitive it is, and information about the nature and purpose of the processing and whether the data actually ever gets accessed wasn't called out in the judgment. So we would expect to receive some guidance from data protection authorities on this point in order to help companies assess what factors would need to be included in the case-by-case assessment that they're being told now needs to happen. It certainly seems logical to us that the type of data transfer impact assessment that may be more commonplace will not only look at the laws but also the context in which the transfer is being made. I'm going to hand over to Marcus now briefly to discuss the impact that this has on the UK.
Thank you, Lara. Yeah, no, all this talk of adequacy suddenly makes us think of Brexit and the UK in its desire to get a positive adequacy finding from the European Commission so that personal data can flow freely from the European Union to the UK after the 31st of December. And so it is relevant to ask whether this decision will have any impact on the UK's application for adequacy and indeed whether the UK will actually follow it after the 31st of December, because the UK will not be in the European Union and will have more latitude to diverge from European Court of Justice rulings. In terms of the impact on the adequacy finding, the UK has been in the dock with the European Court of Justice for bulk surveillance programs in the past, and rather sort of bad timing, the Advocate General to the Court of Justice gave an opinion in relation to a Privacy International case relating to the UK's collection of communications metadata in bulk for national security purposes back on the 15th of January. And that opinion was a negative one, saying that the UK's laws were not proportionate. And there is a sort of Court of Justice ruling which will follow and probably be handed down in the period that the Commission is making its finding on adequacy. So that will stir up the sort of pressure on the Commission sort of not to make a positive finding. I don't think Schrems2 has actually changed the test that the UK has to meet. So it shouldn't change the bar, but it probably has made it politically harder for the EU Commission to actually be flexible and find adequacy. And this is particularly because we're seeing how privacy activists can make complaints to data protection authorities, which then make preliminary rulings to the European Court of Justice, which then invalidate these findings. So I think that just means that the kind of stakes are higher and the grounds have to be very solid for the Commission to actually make that conclusion. So I think our view is it has made it harder because of the political environment, but it hasn't changed the legal bar. Another question that we get asked is, would the UK maybe just roll over its Privacy Shield agreement so that data can flow between the UK and the US, and that would help the UK to get a better trade deal? We think that is also unlikely because the UK is going to be quite fixed on getting this adequacy decision, and if it did decide on the 31st of December to kind of sort of kindle a UK-US privacy shield, that that would be seen as a sort of non-compliant onward transfer through the EU lens, thereby jeopardizing its adequacy position. So we think that's probably less likely. So that's just a little Brexit interlude. I'm going to hand you back to Laura to continue with the analysis on the impact on the standard contractual clauses.
Thank you, Marcus. Okay, so we mentioned before that one of the main points coming out of the judgment is the need to undertake an assessment when using standard contractual clauses. But what follows from that is that if a data exporter undertakes that assessment and doesn't think that the standard contractual clauses alone provide enough protection for personal data in light of its assessment, it can consider, or it should consider, whether it could implement additional supplementary guarantees to help it get the rest of the way. Now, before I explain precisely what the judgment says about this, it's probably worth just commenting briefly on the difference between the assessment under standard contractual clauses on the one hand and an adequacy decision on the other. So when the Commission makes an adequacy finding, it will have already considered all of the elements outlined in Article 4 that we had up previously in relation to the laws of that country, including the surveillance laws and the law enforcement access laws. On the flip side, of course, the standard contractual, when they came up with the standard contractual clauses decision, this assessment hasn't been undertaken in relation to any third countries. And therefore, paragraph 130 and 131 of the judgment makes it clear that in the absence of an adequacy decision, it is for the exporter to provide appropriate safeguards, which the standard contractual clauses might form part of, but the additional safeguards that follow following an assessment would also form part of. So this is a sort of new way of looking at the standard contractual clauses. I think most people previously thought that the SCCs almost had the same status as an adequacy decision once the SCCs were in place, and that nothing further was required. But yeah, as has been mentioned, that is not the case. And instead, it may be necessary to implement supplemental guarantees if the assessment that you've undertaken shows that the laws of the data importer are not essentially equivalent to those in the EU. And this, of course, begs a sort of a plethora of questions. Firstly, the question is, of course, who determines these supplemental guarantees? Well, it seems from the judgment that the expectation is that it is the exporter, possibly with a little bit of help from the importer, but clearly the exporter, as the party that's subject to the European or EU data protection laws, has the greatest incentive to come up with these additional guarantees. The second question is, well, what kind of measures might these supplemental guarantees be? And this is probably the most pressing question, and one where we hope that the EDPB and DPAs will provide some more guidance. But thinking it through, we think that it could possibly include a range of things. That there might be a requirement to be more transparent about which countries' data is being sent to, why and how, so that individuals can better evaluate the transfer before electing to use a service. Of course, that's only really relevant if it's optional. There might be what we're terming transparency reports, and by this I mean reports that a company publishes about the number of requests it typically receives from government authorities for personal data and how it handles these types of requests. Although query, really whether that offers any additional protection. There might be some extra contractual guarantees, so requiring regular reporting of the importer or enhanced termination rights. Although, as mentioned at the start, one of the key points coming out of this is the fact that the law enforcement authorities are not party to the agreement. So that might limit the usefulness of additional contractual provisions, and instead we may be looking more towards what technical additional measures can be put in place, such as encryption or tokenization. Now, of course, the relevant measures will need to be determined by reference to the relevant transfer. So, encryption would only probably work in the case of pure data storage, or if, for example, the particular interception and surveillance law only permits access to data when it is in transit or at the borders, then maybe something that deals with that particular issue, so encryption at transit, might constitute an effective safeguard. So they're some of the issues that, or some of the measures that we might start seeing develop. And perhaps controversially, when we've been thinking about where this might land, it seems at least feasible that maybe we get to a position where there almost is a standard set of additional measures that always sit alongside the standard contractual clauses and effectively apply to every transfer to a non-whitelisted country under SCCs, without the exporter undertaking a large amount of inquiry into the importer's laws. I mean, this is clearly not what the court is saying should happen, and it remains to be seen whether that is how practice develops. But certainly, I think it will be the case that there will be additional measures sitting alongside standard contractual clauses from shortly. I think it will become common practice. So the judgment looks in detail at the obligations of the parties, but it also pays particular attention to the Data Protection Authority's obligations. And by way of recap, under the standard contractual clauses, there are some provisions that already provide for some Data Protection Authority DPA involvement. I mean, firstly, there is a footnote in the standard contractual clauses that recognises that public authorities do access personal data in importing, in the jurisdictions of importing of data importers, and that this needs to be allowed, provided that it does not go beyond what is necessary in a democratic society. So this is effectively what has to be assessed: are the access rights, do they go beyond what is necessary in a democratic society? The importer has to notify the exporter if they think that they cannot comply effectively. Then, so if their laws do go beyond what is broadly necessary, and if an exporter receives that notification, the standard contractual clauses provide that they must suspend the transfer, or if they continue the transfer, they have to inform the Data Protection Authority. So none of this is new, but companies haven't typically paid much attention to those provisions. So what is new is that the right of the exporter to suspend or terminate transfers when they get informed that the importer can't comply with the SCCs by virtue of laws that it is subject to, now really isn't just a right, but something that the exporter is required to do. And if it doesn't do this, then it needs to provide a copy of the notice to the DPA, who will then investigate. And the judgment emphasised in sort of big flashing lights that data protection authorities have got an obligation to investigate in these circumstances and to intervene if they find that data subjects are not being given the adequate level of protection. Now, this is obviously something that few, if any, data protection authorities have had much experience of, and so it will be interesting to see how policy in this area develops amongst them. I mean, certainly the Irish Data Protection Commissioner was concerned that DPAs could take an inconsistent approach into these types of investigations into third country law. Although the judgment of the European Court has said that it has acknowledged this and said in order to avoid the problem, they would expect data protection authorities to use the consistency mechanism under the GDPR and to ask the European Data Protection Board for opinions. Now, just a couple of quick observations on this. I think probably as as with the exporters assessments, the data protection authorities' obligations here are primarily focused on the surveillance and law enforcement access elements of the importer's regime. But nevertheless, the assessment is clearly going to put data protection authorities into a difficult position. Whatever the finding that they make in respect of a particular jurisdiction will be controversial and either subject to attack from privacy activists if they consider it too lenient, or from importer governments if it's too strict. And so it will certainly, to our mind, be a brave data protection authority to make these sorts of findings without the collective cover of the European Data Protection Board. Another issue, which Shiv will come on to when looking at the regulatory response, is that there are clearly differences in how these issues are being dealt with by the DPAs. And you can imagine, even if it goes to the EDPB, you can see why the EDPB might want to shy away from them or the DPAs having to make country findings, and instead they're going to want a framework where the exporters are the ones making the determinations. But unfortunately, data subjects can always challenge an exporter's determination, in which case the DPA is obliged to investigate that complaint, the challenge from a data subject, and to make a determination again. So it seems that all sort of roads potentially lead to DPAs or the EDPB having to effectively assess and categorize the surveillance regimes of third countries. And it remains to be seen really how the European data protection authorities will approach these assessments. But certainly because of negative assessments could effectively kill off certain countries to the European market if a very black and white or blacklist type approach is adopted. One would tend to think that perhaps the assessments will be more nuanced and possibly flexible. But again, remains to be seen how that takes place. I'm now going to hand over to discussion on the Privacy Shield part of the judgment.
Yes, thank you, Lara. So continuing, as you have just learned from Lara, the situation around standard contractual clauses is quite difficult, and the court decision raises a lot of questions in the following. That is not true for the Privacy Shield. For the Privacy Shield, the situation is quite clear, and the answer is direct. The Privacy Shield has been invalidated completely. So whenever you as a company has been relying on Privacy Shield as a previous transfer mechanism, companies have to change the transfer mechanism as the model clauses, as the Privacy Shield is no longer in place. And model clauses might be one of the alternatives given the limitations Lara just talked about. What we consider more important about the Privacy Shield part of the court's decision is the reasoning, because that plays back into the case-by-case assessment of the standard contractual clauses in the future. Because what the court does, it analyzes the U.S. laws on the surveillance and the access rights of public authorities, mainly Section 702 of the Foreign Intelligence Surveillance Act, the U.S. Executive Order 123333, and the Presidential Policy Directive 28. And those taken together mainly lead to three different criticisms. The first one is the court says or held the U.S. laws to be disproportionate, where especially criticizing the bulk collection of data, which is that, quote, not regarded as limited to what is strictly necessary. Again, it is criticizing the bulk collection. The second criticism of the court to U.S. laws is the lack of proper oversight. So it is looking at the Foreign Intelligence Surveillance Court, a specific court which is in place under U.S. law, but this court is not focusing especially on and is not taking decisions on individuals or properly targeted And further, the limitations do not apply to non-US persons. The oversight is one of the criticisms, and probably the most important, and the one the court focuses on quite lengthily, is the lack of redress. So neither this PPD 28 or the Executive Order 1233 grants data subjects a right to complain in court and to action in court against any US data processing. And so that is the problem about those laws. And the last issue the court looks at is the undersea cables, so access to data in transit. And again, two main criticism about that is again the scope, which is extremely broad and not limited, and again the lack of judicial redress against accessing data in undersea cables. So if we take those criticisms of US surveillance laws together, the question is more or less, does that also answer if we can continue to send any data to the United States, if that is continuing to be lawful? And we'll pick that up later in our consequences. But that is in our opinion, the interesting piece about Privacy Shield in the court's reasoning, is how this plays back into the case-by-case assessment of the standard contractual clauses. And we are now continuing with you, Shiv, on the reaction of the authorities on these decisions.
Great. Thanks, Christoph. So as Christoph has mentioned, we'll now discuss what the reaction has been to this much anticipated judgment. So first turning to Max Schrems. Max Schrems and his privacy NGO, NOYB, have been very happy and triumphant about the result, describing it as a, quote, total blow to the Irish Data Protection Commissioner and Facebook, and saying that the US needs to change its laws if it wants to participate in the EU market. What is very interesting is that NOYB has been issuing its own guidance for companies, providing answers to FAQs and even model questionnaires for EU exporters to send to US service providers to ascertain how they will comply with the judgment. This certainly suggests that NOYB intends to see this judgment through to satisfactory implementation and that it won't let matters rest until such time. The Irish Data Protection Commissioner has also responded to the decision. The Commissioner published a statement on the 16th of July welcoming the judgment, but stating that although the standard contractual clauses remain a valid mechanism to transfer data to countries worldwide in principle, in practice, the application of the standard contractual clauses transfer mechanism to transfers of personal data to the United States is now questionable. In a webinar held on the 17th of July, Commissioner Dixon said that companies will need to have some risk appetite in pursuing the option of continuing with the standard contractual clauses and transfers to the US. In an IAPP forum also on the same day, Commissioner Dixon was reported as saying that the Irish Data Protection Commission is not making a definitive statement at this point, but that it wanted to put its cards on the table with the rush by some to suggest that standard contractual clauses are the automatic solution to the 5,500 or so companies impacted by the Privacy Shield invalidation. It therefore does appear that the Irish Data Protection Commissioner is contemplating some form of export impact assessment to accompany data transfers relying on SCCs. We'll now take a brief look at the initial reactions from some of the other data protection regulators and also cloud providers. So turning first to the EDPB, on the 17th of July, the EDPB published a statement saying that it will assist and guide the European Commission to build a new framework with the US, and that it will look at the potential additional measures that companies could take to allow the standard contractual clauses to provide an essentially equivalent level of protection. On the same day, the French Data Protection Authority, the CNIL, issued a brief statement saying that it is working with the EDPB to work out the consequences of the ruling. The Dutch Data Protection Authority published a statement on the 20th of July saying that personal data can no longer be exported based on the Privacy Shield, and that the EDPB is currently assessing the practical implications of the judgment and will issue guidance shortly. The UK's Information Commissioner Office issued a holding statement on the 16th of July, explaining that it is considering the judgment and will be working with the UK government to ensure that global data flows can continue and that personal data is protected. The UK government published its response to the judgment on the 17th of July, stating that it is disappointed that Privacy Shield has been invalidated. As of the 20th of July, the ICO updated its holding statement to advise controllers to continue using Privacy Shield if they are currently using it, but not to start using Privacy Shield if it is not currently being used as an export solution. This is quite an unusual approach, given that the Privacy Shield has been invalidated, and there is also currently no recommendation from the ICO to use standard contractual clauses in place of the Privacy Shield. Several of the German data protection authorities have also made statements. The Berlin Data Protection Authority made a somewhat hardline and political statement after the judgment. It said that transfers of personal data to the US may now not be possible under the standard contractual clauses, particularly when using cloud services, and that data controllers are encouraged to use EU providers immediately. The head of the Data Protection Authority said, "The times when personal data could be transferred to the US for convenience or for cost savings are over after this ruling. Now is the hour of digital independence for Europe." The Data Protection of Hamburg also stated in a press release that transfers to the US based on standard contractual clauses are no longer possible, and that there are hard times ahead for international transfers. Johannes Kasper, who is the head of the Data Protection Authority, said, "Data protection authorities must now critically examine the whole topic of transfers via standard contractual clauses. Ultimately, this will not only affect states which, like the USA, have at least made an effort to give the impression that they are creating adequate structures for data protection. For countries like China, such data protection precautions are a long way off. With regard to Brexit too, the question of permissible data transfers will arise. Hard times are dawning for international data transfers." End quote. The Data Protection Authority of Rhineland-Palatinate has published FAQs on its website, which made the point that there is no grace period for transfers that were previously based on the Privacy Shield, and that they are currently assessing the extent to which binding corporate rules may be impacted by the judgment. So, taking this all in the round, it's clear that how to proceed from here is not going to be straightforward, given the divergence between data protection authorities. Finally, turning to cloud providers, unsurprisingly, a number of cloud providers have issued statements saying that they will continue to use the standard contractual clauses despite the Schrems decision, which is in stark contrast to many of the data protection authorities' views that we've just discussed. These companies will likely be claiming that they have rigorous technical measures that supplement the standard contractual clauses. I'll now hand over to Marcus, who will discuss potential next steps that organizations should take in light of the judgment.
Thanks, Shiv. So what to do next? Don't panic, I think is the first point. There's a lot of alarmist statements being made at the moment. The judgment is very fresh and it is a difficult judgment. Its scope and what you're going to have to do to comply with it is really not clear currently. So the regulatory guidance and how the Irish Data Protection Commissioner is going to enforce against Facebook is going to determine how far you need to go. And we just don't have this yet. So there are relatively few concrete steps that we would advocate at this stage. However, that's not to say nothing will happen. This does have the potential to be very disruptive and costly to comply with. And so you should brief your senior management now on its potential impact. And I think the other piece which your senior management perhaps need to be thinking about is that it is possible that it will trigger a sort of retaliatory tightening or the imposition of further export controls from other countries. And so I think data localization as a concept, there are other countries in the world which have data localization rules already, China, Russia, etc. that looks likely to be more of an issue going forward. And so that is something which your management needs to know about in terms of the sort of direction of travel. I think the second thing that businesses need to do right now is map your data transfers. You've probably done that with the GDPR or other rules, but you may need to go down to another level of detail here. So the impact of this decision really starts with understanding where your personal data is stored and accessed from, because access is deemed to be a transfer under this rule. So you should get an accurate and detailed picture of which personal data, which countries, and what purposes you're using it for. Then you need to check what export mechanisms you're relying on. Out of Europe, you'll likely know if you're using binding corporate rules, but binding corporate rules won't cover all of your transfers. They can only cover the intra-group transfers. So all companies are likely to be relying on a mixture of Privacy Shield for any US transfers and standard contractual clauses for some US transfers and other transfers around the world. Map which ones you're using for which type of transfer, and try to map them precisely. I think at this point, as I think it's probably come out from the other speakers, is that the Privacy Shield is dead. I'm not quite sure what the ICO's website is getting at when it sort of is not recommending controllers to put in place standard contractual clauses if they're relying on the Privacy Shield in the past. I think our view is that putting standard contractual clauses in place for transfers to the US if you were relying on a Privacy Shield is a bit of a no-brainer. You might as well have a mechanism which is stated to be valid, albeit that you have to do more to comply with it, than to have a mechanism which has been stated to be invalid in place. So we've got a bit of a divergence of opinion with the ICO on that. When you're doing your mapping, it's also pretty good to know where derogations to the export prohibition might apply. So where, with your transfers, if it might be possible at a push to rely on necessary performance for contract with a data subject where consent might work, I think it's worth noting that, because we may get to a world where making this assessment is very difficult, and you may need the cover of derogations going forward. So that assessment should be added to the mapping. I think you do need to draw up a list of potentially affected countries. It's tempting to kind of duck this issue that sort of, this will come out later, but you do need to think about transfers to the other countries that might suffer the same fate as the US. And this list, could be quite long. I mean, if the US has been questioned this way, then I'm afraid it's got to be the case that transfers to countries like China must be questionable without some further safeguards too. So in order to make that list, you're going to need some criteria as to how you're going to judge the countries by. And I think that list is going to be a very preliminary list at this stage, as you don't know how the regulator is going to act here. You don't know how far you need to go in your assessment. You don't know what format the analysis needs to be in. So this is very much a preliminary assessment. And as Lara said, you're focusing on what you know about the laws of the country and the rules on public access authorities have in that country. Are they clear? Are they precise? Are they accessible? Are they proportionate with regard to legitimate objectives pursued? And whether there's an independent oversight mechanism for access, and whether data subjects, not just residents of the importing country, but all data subjects, can enforce their rights and obtain proper redress. Now, that sounds quite a daunting list of things you've got to assess, and it's not an area of law that there's lots of ready-made synthesized analysis on the blocks. Law firms big law firms like Norton Rose Fulbright have done studies across various countries on this type of issue, and the work is quite complex. At this stage, we really would expect any such analysis to be very high level and preliminary, so you wouldn't sort of incur fees to go to town on this, because, as I said, the criteria aren't clear, and the necessity of even undertaking detailed analysis has not really shown itself yet. And I suppose the other thing is that it might be that the EDPB or your data protection authority do this analysis for you. Having said that, we've really got our doubts as to whether, given the cost and the complexity of doing this, that is the route they're going to go down. We think there's quite a good chance that this will remain a task that exporters and importers need to address. Another way of thinking about that task is it really is in an offshore importer. So if you're an Indian service provider, it's really in your interest to have a ready-made analysis of the laws in your country, and to have them analysed in the most sort of favourable light, so that exporters can continue to export to you. And so that may be a route which exporters can leverage to sort of get some of the analysis without having to sort of pay their own lawyers to do it, but it will need to be sort of checked. And then if you're an importing service provider, you're obviously going to need to be reassuring your customers of the validity of standard contractual clauses, as indeed we've seen out in the market lots of statements from cloud service providers that model clauses remain valid and that they're relying on them. And I think if you're an importing service provider, you're going to have to start thinking about the safeguards and starting to make public statements about them as well as guidance comes out. In terms of the safeguards, Lara talked about those, and I think it is worth thinking about those quite hard now, because depending on how onerous it is to actually implement the safeguards, I don't really see that much downside in starting to implement them regardless of which country you're sort of exporting to. So those sort of safeguards could be encryption in transit if the surveillance is happening at the borders of countries. Could be better transparency provisions and more due diligence as to how the importers actually deal with public authority requests, so that you're more confident and able to show to the data protection authorities that you're sort of controlling these requests. It could also be the ability to direct or restrict access on certain processing activities from a country, which is, the equivalent to sort of turning off access. And I think once you've sort of identified your high list of sort of high risk countries and sort of how effective any additional safeguards would be in addressing those issues, then I think you do have to consider the costs of relocating processing operations from high-risk countries back to countries which are either EU or countries which have had an adequacy decision, such as Canada. I'm not saying that you should relocate, but I think that understanding the alternatives and the costs is something which is sensible to do at this point. In terms of deals going forwards, then building in flexibility so that you are able to relocate as this judgment and the guidance unfolds is recommended. But actually, that's really the kind of list of things which we think are advisable at this point. And so it's preparation rather than action. at this point. And as the guidance comes out, and we've clearly got the European August break, which may mean that guidance takes longer to come than perhaps we'd all like. But I think there is a bit of a waiting game ahead of us for at least the next month. So that is the end of the prepared materials. We have 2 minutes left. Just going to check if we've got a couple of questions we might be able to answer. Here's one. I'll just try to squeeze it in before the end. David, maybe you could answer this one. We're headquartered in Germany and use a number of US-based cloud providers. We tend to use their US data centers because it's cheaper, but they do have facilities in the EU that we could use instead at an extra cost. If we do this, will this get us around the problems you've talked about?
I think the answer to that question is yes. I mean, that would probably be a less risky solution into the present climate. There's a lot of unknowns, and there may be ways to still use the U.S. provider on an ongoing basis, depending on what safeguards you could put in place to avoid the mass surveillance issue that's at the heart of this opinion. But if you don't want to go through that analysis and are willing to spend the extra money, then the move, I think, would potentially reduce your risk of non-compliance.
Thank you. And I think maybe time for just one more. So we're in Europe and we use a US-based HRIS, I think it's a Human Resources Information System. We use their Irish data center, but customer support is provided from the US. Is this okay? Maybe Christoph, could you take this one?
Yeah, sure. So the question is how we could limit the access on the US side to the data and to which extent it is subject to the surveillance laws we just mentioned. So there might be room to argue that for HR data and for just maintenance access, this is a different scenario. But I open it to the cloud. Marcus, David, to add to that.
Yeah, I think, Christoph, you're right there. And I do want to point out, and maybe I should have articulated this more clearly at the very beginning. I mean, the way that the mass surveillance works, it uses selectors to identify relevant communications that need to be pulled out. And there's a limit to the number of selectors, and I won't get into what the different U.S. entities sort of provided to the court on this. I think that sort of passed us by. But I think that does teach us about the safeguards, because to the extent that the communications with the in this case, the customer care center, or the support center in the U.S., let's assume that they're actually transferring personal information to bring it under the scope of the question. But if they're not using email or not using selectors to communicate back and forth, then it's quite possible that those transfers avoid the mass surveillance and would have the safeguards necessary and would be able to supplement, as Laura put it, and as the opinion states, the standard contractual clauses. So you could do that assessment, see that if they're using standard contractual clauses to do that transfer, that you have the safeguards in place, maybe already in place, but need to be articulated in a way that provides the data exporter the comfort they need that they're in full compliance. And that's the kind of assessment I think, Marcus, you're talking about when, in your session at the end, and, the level of assessment you need to do, I think will vary depending on the risk and the type of data, and would really be a risk-based approach.
Thank you. Okay, just a couple more questions, and then we'll draw this to a close. I know we're over. When should we expect DPA EDP guidance? I might answer that one. I think that the timing with the summer break coming up and particularly the Irish court not sitting during the summer means that I think that guidance is not going to be coming until towards the end of August. But I have no inside track on that or any other sort of tea leaves that can back that up. But that I think is my view on that. Another question is how do you square Canada getting an adequacy decision when it's part of the Five Eyes together with the UK? I think the answer to that one is that we hope that the UK gets an adequacy decision as well, and that Canada keeps its adequacy decision, and that the investigation of the UK doesn't torpedo the Canadian position as well. But the analysis is very nuanced as to the controls which Canada has in place in respect of its surveillance program. So an easy, crisp answer on that's probably not possible. I think the last question, maybe address this to the floor, is we have one question saying, can you see any immediate impact to those who rely on BCRs for intragroup transfers? Anybody like to take that one?
I mean, Marcus, I would say that on that, obviously, some of the findings in the judgment potentially still impact the transfers that might be made under the BCRs. I guess though with BCRs you have still you've had them reviewed by data protection authorities, so there has been an element of assessment already as to your internal measures, which might include some of the sort of additional safeguard type provisions potentially that are being expected. But I don't think BCRs gets you entirely around the issues raised.
I would agree with that. And then one last question, so I can't resist. Does it feel like we are back in the realms of the ICO's old self-assessment of adequacy for Principle 8, albeit with more rigor on the destination country's laws, and of course bolted onto the standard contractual clauses? That is an interesting question. That the UK and a couple of other European countries did used to have a route open for export where you could make your own adequacy of the country's data protection regime, and I think the answer is yes, we are. I think into that world, but I think it's one which is much less sleepy than it was when the ICO was doing it, when nobody bothered to really take the point. Now I think there's going to be lots of scrutiny, so that assessment is going to be a little harder work to do.
And I think it would be it's probably assessment plus SCCs as opposed to just the assessment, because there's obviously this Article 49 does allow for an element of organisations to do limited transfers on a sort of exceptional basis if they've assessed the circumstances, but obviously that's intended to be very limited. So I think this assessment would be one that is coupled with the SCCs as opposed to the old ICO mechanism.
Absolutely, thank you for pointing that out. That you would have to have the standard contractual clauses as well.
So, ladies and gentlemen, that concludes today's presentation. Thank you very much for joining us. On behalf of my colleague in Australia, Jim Lennon, and our colleagues overseas, we're delighted to bring you this information. It's obviously a complex issue and is one that is continually evolving, and we will seek to keep you updated as things do progress. And particularly, as Jim mentioned at the outset, the issue for Australian companies around the standard contractual clauses is an area that should take some scrutiny. And so if, as an organisation, you do deal a lot with the EU and there's data transfer, then please feel free to reach out to us, and we're happy to talk to you about some of the sorts of issues that we've been seeing with clients as a result of Schrems2. So with that, thank you very much once again, and please enjoy the rest of your day. Thank you. Goodbye.